the ABA has made public and accessible some 45,000 penalties, sanctions, and restrictions that are distinct, as we just heard, from the direct consequences imposed as part of the court's judgment at sentencing. This has huge implications for defendants and for policy that could help reform our field. We owe our colleagues at the ABA a debt of gratitude for taking on this formidable project. I remember I was at NIJ. I can date this, Jim. It must have been 2000. I wasn't at NIJ. I was at a research organization when NIJ issued this solicitation. Must have been 2008 or so. And we very, very briefly considered applying to the competition. And, you know, we cared about reentry. We cared about incarceration. We certainly cared about the penalties of a criminal record. Yet we could see that this was a massive undertaking that would require a fleet of lawyers and a dogged determination to build something that had never been built before. And we could see that it was going to have to be user-friendly, sortable, updatable, and constantly updated. It was a very tall order. And so now from my perch at the Justice Department, I extend a wholehearted thank you to the ABA for taking this on and providing the field with such an important and unique tool. So the creation of this tool was funded by NIJ, and it surely holds important research opportunities. But the inventory is also a practical tool that can inform the decisions today of judges, lawyers, and defendants. There are so many lives at stake here. In fact, 1 in 3 U.S. adults has an arrest record, mostly for relatively minor, nonviolent offenses, and sometimes decades in the past. The long-term, sometimes lifetime impact of a criminal record is going to keep many people from obtaining employment, accessing housing, higher education, loans and credit, even if they've paid their dues, turned their lives around, are qualified and unlikely to reoffend. At the same time, research sponsored by NIJ shows that people who stay out of trouble for even just a few years are largely indistinguishable from the general population in terms of their odds of another arrest. Now, of course, individuals need to be held accountable for their actions. As Senator Leahy stated at the launch of the National Inventory, there should be serious consequences for criminal activity, but most of those convicted will return to our communities, and we should be doing everything we can to give them the skills and opportunities they need to reintegrate successfully, rather than returning to a life of crime. That is the right thing to do, and it makes us all safer. And so at the Justice Department, we believe there are substantial opportunities to simultaneously hold people accountable, improve public safety, and to help motivated individuals who have served their time and paid their debts to compete for a job, attain stable housing, support their children, and be productive, contributing members of society. Not only are these things not mutually exclusive, they actually go hand in hand. By helping justice-involved individuals succeed, we improve public safety. This commitment stretches across the Obama administration. More than 20 agencies are working together as part of the Federal Interagency Reentry Council to reduce the broad set of collateral consequences, barriers to education and employment, health and housing, among others. Attorney General Holder has personally championed this issue. He's written to every state attorney general, asking them to assess their state's statutes and policies to determine if any should be eliminated so that people who have paid their debt to society are able to live and work productively. And 1 year ago this month, the AG delivered a powerful call to action on felony disenfranchisement, which keeps 1 in every 13 African American adults from voting. In the words of the AG, what is clear and abundantly so is that these laws sever a formerly incarcerated person's most direct link to civic participation. They cause further alienation and disillusionment between these individuals and their communities. And it's counterproductive to exclude these individuals from the voting franchise once their involvement with the correction system is at an end. While we have a long way to go here, many states have answered the call in a broad way for reform, and the momentum is encouraging. A recent report by the Vera Institute of Justice found that over the last 5 years, 41 states have enacted some 155 pieces of legislation to mitigate at least a part of some aspect of collateral consequences. The Attorney General also asked the Reentry Council agencies to review our own regulations with an eye to how and where certain barriers can be eliminated or tailored without compromising public safety. The Justice Department Civil Rights Division coordinated this cross-agency effort, a review of hundreds of regulations across 12 agencies. And I want to acknowledge Nicole Nadumale and Maisha Braden, who I think are in the room today and worked from the Perch Civil Rights, and now Maisha back there from the Domestic Policy Council at the White House to oversee this coordinated review. The vast majority of regulations were deemed appropriately tailored for their purposes, but some changes have been proposed, and others are currently being considered in their home agencies. For example, in the employment arena, the EEOC, Equal Employment Opportunity Commission, the Department of Labor, and the Office of Personnel Management have all taken actions to amplify and clarify good hiring policy when it comes to those with arrest or convictions histories. More recently, the Small Business Administration proposed to amend their eligibility rules for a microloan so that people on probation and parole are not automatically excluded. Just this week, the Department of Health and Human Services announced plans to examine the barriers faced by individuals with a criminal record who are trying to enter the healthcare workforce. And the Department of Justice's Bureau of Justice Assistance is currently seeking a second chance fellow, someone who can bring to the job both their professional expertise and their personal experience. We're looking for someone who specifically has formerly been incarcerated and now has expertise in this area. This position will advise the Second Chance programs and the Reentry Council. Another exciting development is a forward-looking policy introduced by the Attorney General at the ABA's 2013 annual meeting when he announced the Smart on Crime initiative. As part of this effort, the AG issued a memorandum directing leadership across the department to take collateral consequences into account when proposing any new or updated regulation or guidance. This policy is so important because it institutionalizes these reviews moving forward. Now, I want to pause here and acknowledge Jim Cole, our former Deputy Attorney General, who played a huge role in designing and implementing the Smart on Crime effort. He was also a personal champion of all of our reentry efforts, and his leadership is the reason why we can talk about so much of the momentum we've been able to make the department. So thank you. I also want to share with you some important inroads we're making on the legal services front. As you may know, the White House and the Department of Justice launched a legal aid interagency roundtable to raise awareness about the profound impact legal aid programs can have on the myriad issues we're discussing at the summit. As a result of this collaboration, several large grant programs, including our Second Chance program and the Department of Labor's REXO programs, now allow for the use of federal funds to pay for legal assistance to expunge criminal records, secure driver's licenses, modify child support orders, and litigate inappropriate denials of housing or employment and violations of the Fair Credit Reporting Act. We're expanding on this commitment with new resources, too. Using Second Chance Act funds, our Office of Juvenile Justice and Delinquency Prevention provided HUD with funding to implement a juvenile reentry legal assistance program with public housing authorities and in partnership with legal assistance organizations. This opportunity is forthcoming from HUD. The program will primarily focus on the expungement and sealing of juvenile records, as well as provide other civil legal services. And we continue to explore new opportunities that are going to broaden access to legal services along these lines. Finally, we're going to work with the ABA and others to create practical tools that build on the national inventory. Eric Martin from NIJ, he's here with us today, and he's really shepherded this project for years now. And he's working closely with ABA to develop a bench book to assist judges in explaining to the accused the existence of collateral consequences prior to the entry of a plea. We seek to help judges, prosecutors, defense attorneys, and the accused understand the full spectrum of sanctions that a conviction entails. In closing, I want to touch on President Obama's meeting with the governors earlier this week, where he spoke about the great opportunities for criminal justice reform. He celebrated the fact that last year, for the first time in 40 years, both the incarceration and crime rates went down together. The president spotlighted states, both red and blue, for making bold changes in their justice systems. In Connecticut, for example, Governor Malloy recently announced proposals to create a second chance society. And Georgia was highlighted for bold front-end reforms. Georgia also, just this week, became the first southern state to ban the box. It's time for us to be optimistic about what's possible. It's time for us to learn from one another, and it's time to get things done. I look forward to the rest of the summit, to hear your stories, your lessons, and your ideas, so that we can continue to work together to promote reforms that are fair, that are just, and that lead to safe, healthy, and strong communities. Thank you.